Hello, good day, everyone, and welcome to our second quarter Legal Issues Committee webinar. Joining me today is Caren Counsel from the Wolf Firm, who will be addressing the impacts of the recent court decision on the Center for Disease Control moratorium on evictions. Also, Sarju Naran from Hoge Fenton will address the complex issues, particularly in no other state like California, of HR matters with work from home. And Eric Troutman from Squire's Patton Boggs, will address the very important recent Supreme Court decision in the TCPA Facebook case and related matters coming out of that. Some very important things. I'm Rich Andriano with Ballard Spahr, and I will start out with a brief CFPB update. And I want to keep it brief because some of the other matters are so important. I do want to leave appropriate time for that. Please note that this webinar is being recorded, so probably by tomorrow it will be uploaded, and you could access it either through the CMBA committee page or on the CMBA's YouTube channel. So with that, I want to again welcome everyone, and let's start out. And I'm going to focus on ability to repay qualified mortgage issues. So, Dustin, if you could move us to the first slide. And what has happened recently, and it's been causing a lot of confusion in terms of what the Bureau has done and what Fannie Mae and Freddie Mac has done. And there's a very important thing at the end I want to highlight that industry members haven't quite seized on as much as they need to. What the Bureau did was take the mandatory compliance date for the new general QM, which is based on an APR structure as opposed to the original QM, which was based on a debt to income structure. And they moved that date from July 1, 2021 to October 1, 2022. So next year, not this fall, but next fall. Now, their stated rationale for that was they wanted to leave the original QM rule, the GSE patch QM rule, and also have the new general QM rule all in effect for an extended period of time while we're in this period where borrowers are facing financial hardship from the COVID-19 pandemic. The thought was this would give more options, perhaps moving borrowers out of their existing loans into new loans if modifications wouldn't work. The industry and many others think that that is a smokescreen and that the real reason was to provide a delay so that the Bureau could actually revise the new general QM rule. Now, interestingly, this rule has support both of the industry and from many consumer groups as well. So comments on the proposal to delay the mandatory compliance date had both industry and consumer group representatives urging the Bureau not actually amend the rule, and many also urging them not to delay the compliance date, let it become fully effective and have the other QM rules expire. But that's not what they did. They did extend it to October 1, 2022. What that means is for applications that are received before October 1, 2022, the original general QM based on the 43% DTI, not well used, but it's still alive. The GSE patch QM, the most used, is still alive technically. We'll say why I do technically in a moment. And the new general QM are all available. Once we reach October 1, 2022, of those three QMs, only the new general QM will be available unless the Bureau further extends the date. They left that open. They're going to see how things are progressing as we move into next year. Now, importantly, the FHA, VA, USDA, and small credit or qualified mortgages are not affected by any of this. They're still available. None of this affects the usage of them. Important, however, was what Fannie and Freddie are doing. They have announced that for applications taken on or after July 1, they will purchase new general QM loans, but not the original DTI-based QM loan, and importantly, not the GSE patch QM loan. What that means is, come for applications on or after July 1, 2021, you could make an original QM loan based on the 43% DTI. You just can't sell it to Fannie or Freddie. You'd have to have some other outlet for it, either retain it or sell it to a private investor. The GSE patch, though, however, technically becomes inoperative because the key to the patch was the loan would be eligible for sale to Fannie or Freddie, and they've said they're no longer going to buy those loans. But as you would see in a Ginsu commercial, but wait, there's more. Let's move on to the next slide. This gets even more complicated. one thing they also announced, and again, this was in the Fannie Mae Lender Letter 2021-11 and the Freddie Mac Bulletin 2021-19. I urge you to pay particular attention to those issuances. And my understanding is Fannie Mae is going to come out with more guidance as through discussions I and others have had with them, they realize the industry didn't fully understand a point that I will be making. Important for applications on or before June 30th of this year, you must deliver them to Fannie or Freddie basically before August 31. Well, that's not a lot of time, particularly for loans on new construction, where you take the app and you're closing that loan way, way later. They did create an exception for construction to permanent loans, the one-time close, where they will take delivery of that by February 28th, 2022. Still not a tremendous amount of time when you're involved with new construction, particularly in winter period and colder climates. Didn't address at all, however, loans on new homes being sold by a builder, where it's not a construction or permanent loan, it's just a loan. I take the app now, 9 months later, I close. They technically have addressed that with a little wrinkle regarding the GSE patch. What they said is for application dates, loans with application dates before March 1, 2021, which is the effective date of the new general QM rule, you may sell those loans to Fannie or Freddie if they meet the terms of the new QM rule. Now, interesting, that means it's not a QM loan under the new QM rule if you took the application before March 1, because the rule didn't become effective till March 1. But it effectively can be a QM under the GSE patch because Fannie or Freddie will buy the loans. Now, they've said you have to comply with the new QM rule. We'd like to know exactly what they mean. Obviously, you've got to comply with the APR limit, but what else probably means the debt to income consideration requirements will fully apply. That's where we could use some more guidance. Now, here's the very important point I really wanted to drive home. There's a special APR calculation rule where if the rate may change within 5 years of the first payment due date, not the note date, the first payment due date, for the APR purposes of comparing the APR to average prime offer rate, you have to use the maximum rate that would apply during that 5-year period as for purposes of calculating the APR. So that's going to knock the basically 1-year ARMs and 3-year ARMs out of compliance. They will not be QM loans. 5-year ARMs might be QM loans, depending on the initial adjustment. Now, here's the important thing. The rule already required, both prior QM rules and the new QM rule, that to determine the monthly payment for purposes of underwriting the loan, you have to use the payment based on the maximum rate that applies during the first 5 years. Now, under the QM rule, you could use that rate and apply it to the loan balance at the time the rate is achieved. 5 years later, for instance, balance would be lower, paid down, or you could just make the calculation simple and use the original principal balance. That's what the rule allows. Fannie Mae, however, has said you must use the original principal balance. A lot of loan origination systems are programmed to use the principal balance at the time the maximum rate is achieved, not the original principal balance. You need to check your loan origination system, and if you want to sell that loan to Fannie, and my guess is Freddie will probably come out the same way, you're going to have to alter how your system calculates that. Will that mean, will there be some limited number of people who don't qualify using that calculation as opposed to the lower balance? Yes, there will. There will be some lesser amount of qualifications, but you need to understand that, and that's very important. Again, I think Fannie's going to come out with additional guidance in this area. I hope Freddie would as well. Stay tuned. One thing we're still waiting for, FHFA's position could change because we're waiting for the Supreme Court decision in Collins v. Mnuchin, which could result in the FHFA director becoming removable at will of the president, which, if that was the case, President Biden could replace Mark Calabria immediately, maybe with someone who has a different view of what loans Fannie and Freddie should be able to buy. The Supreme Court website lists this Thursday as the next and last opinion issuance date for the term. So this may be a very interesting week in the mortgage industry. With that now, Dustin, I'd like to turn it over to our next presenter.
That was super awesome. Like, I don't even know what the QM stuff is, but I just learned so much. And more importantly, I believe deeply that you know all about it, Richard. I'm pointing in the wrong direction. Great work, great presentation.
Thank you.
All right, so look, I'm going to talk about a couple things with the TCPA. You folks know me, of course, I'm the czar of TCPA world, Eric Troutman, happy to be here with you. Facebook, let's go to the first slide. I assume that everybody on this little call, if you know about the TCPA, if it matters to you, you already know about Facebook. If you don't, then I don't know what to tell you. You missed something really, really big. The Supreme Court has interpreted the term ATDS, the Automatic Telephone Dialing System in 227A1, very narrowly. It has said that the Marks decision out of the Ninth Circuit that applied the definition broadly to apply to all automated dialers, that was wrong. It was always wrong. The definition of an ATDS is specifically set forth by Congress in the TCPA, and it requires the use of a random or sequential number generator, either in connection with the storage or the production of phone numbers to be dialed. That means if you're not using a random or sequential number generator, you're not using an ATDS, and the TCPA does not apply to your auto dialer. Now pause, it still does apply to your pre-recorded voice system and your direct drop system and your DNC. We're going to talk about that in a second. But when it comes to a pure dialer, think predictive dialer, unless your system is using a random or sequential number generator, the Supreme Court has spoken, thank you Facebook, and has said that you are not using an ATDS. Pause. Hopefully, you've also heard about footnote 7, which is a very important little footnote here in the Facebook ruling. And what it does is it says, yes, you have to use a random or sequential number generator, but you might not have to use it in the way that you think you have to use it. If you are using a random or sequential number generator in order to select the position of phone numbers to be dialed, that could convert your system into an ATDS. When you look at that footnote and you combine it with footnote 6, which I don't have in front of you, which says that human intervention is no longer the threshold, you have to recognize that what Facebook has done is shift the paradigm. For so long, we've been focused on the word automatic. We've been focused on whether or not your system is using human intervention to determine whether or not you're using an ATDS. Those days are gone. Those days no longer exist. What matters now is how are numbers being selected for presentation to the dialing equipment from the system of record. When you're pulling out those records to create a campaign to send to your dialer file, how is your dialer selecting the order in which those phone numbers are going to be called? That is now the critical issue. And taking a look at the latent propensity, the latent capability of your system to use randomness or sequentialness in selecting the path and the sequence for dialing is now the most critical thing you can do to determine whether or not your dialer is an ATDS. As we go to the next slide, we're going to see that we do not yet have a whole lot of case law built around this yet. We have the Supreme Court setting. Next slide. That was my very humble, kind of subtle way to move slides. There we go. We have the Supreme Court now setting forth the new rule, but we don't have a whole lot of case law yet applying the new rule. We do have 4 cases. Okay, 3 of them are not really that important. They're glancing blows. They're at the pleading stage. The very first case has allowed a TCPA complaint to get past the pleading stage where allegations of random or sequential number generation exist in the pleading. We also have a case that's looking at the usage of the system's capacity for random and sequential number generation as opposed to the capacity itself. That's important, but again, kind of glancing at the pleading stage. But look at Barnett. Look at this the very bottom case. It just came out on May 28th. Really interesting case, a summary judgment ruling in favor of a small bank, Bank of America, and what it finds is that the Avaya predictive dialer system, very popular system, is not an ATDS under Facebook. Now that's great, but before we all start, playing our kazoos and popping our champagne, keep in mind that the factual record here was very thin. The court did not have in front of it any real evidence regarding the capacity of the system to use a random or sequential number generator other than a declaration from Avaya. And it's great that the Avaya has provided that declaration, but the plaintiff's position is, hey, look, we didn't get any discovery. The defendant didn't really provide us with any information. Nice work, Bank of America, not giving them any information. But seriously, right, they went to bat against a defendant's motion for summary judgment with empty pockets. And when you do that, you know that you're going to lose, okay? So this Barnett case is a great win, but just keep in mind it's not a great win substantively in the sense that the court didn't have the opportunity to fully explore how the system was actually operating. So this is not the last word on whether or not predictive dialers are subject to the TCPA after Facebook. They probably are not, okay? I believe 90 to 95% of courts are going to find that predictive dialers are no longer an ATDS, but you have to go slow because that body of law needs to develop and it hasn't developed yet. We are, of course, keeping an eye on every single Facebook ruling as it comes out on tcpaworld.com. And we've got this cool little resource page where we're going to give you every single case as it rolls out in one little handy page. It's on tcpaworld.com. You can check that out. Next page. So here is my dialing technology post Facebook. Remember, pre-recorded calls, artificial voice calls, IVR, ringless voicemail, and calls to phone numbers on the DNC without scrubbing, without an EVR. All of that still subject to the TCPA even after Facebook. The TCPA is not dead, folks. There are a ton of new cases being filed around pre-recorded voices and the DNC. So keep this stuff in mind. In the yellow, right? Yellow means go, but cautiously. We've got the predictive dialers, the preview dialers, the blast text platforms, and the human intervention systems, all of which are probably okay after Facebook. But because of the footnote 7 issue and footnote 6, we want to give this just a little bit of time to mature and breathe like a fine wine so that we can make sure that this is really safe. So if you're using these systems, continue to be a little bit more cautious. And then you've got the green light, right? The stuff that's kind of on all fours with Facebook, AI and interactive text and triggered text technology, right? That's exactly what Facebook was using, a piece of technology where if you accessed an account, it would automatically generate a one-to-one text message to a consumer. That one-to-one interaction, right, is what's critical to really leverage Facebook safely because it assures that random and sequential number generation from a sequencing perspective is not taking place. So that's what you're going to be looking at. There's my little stoplight. Feel free to make use of this slide. Next slide, please. Speaking of helpful slides, I've put together these really cool little informational calling and marketing calling flow charts. They're available on tcpaworld.com. Thousands of folks have already downloaded these, wanted to provide them to you, to the attendees here as well. So now you've got them. If you hadn't had them before, you'll see a little plug here for the Great Vegas Compliance Palooza, July 22nd, 23rd in Vegas. Hopefully you'll make it out there. It's gonna be a big show, it'll be fun. Next slide, just Dustin, so everyone gets to the slides. Here again is the flow chart, right? The marketing flow chart, and you can see right here what level of consent do you need. Just follow the little flow chart, handy dandy, simple. Again, you can get those on the website. Next slide. One other thing I want to chat with you folks about, other than Facebook, is CREASY. Hopefully you all remember that the Supreme Court last year also looked at the TCPA in a case called AAPC and determined that content-specific exemptions, when they are folded into a broader restriction on speech, are unconstitutional. Why? Well, because the government can't favor certain speech over other speech. That's unconstitutional. And so the AAPC decision struck down the government-backed debt exemption that was part of the TCPA from 2015 to 2020. And now the question is, can you sue people for making calls that were in violation of the unconstitutional TCPA? Remember, I just told you, the TCPA was unconstitutional from 2015 to 2020. Yet there's a bunch of lawsuits regarding phone calls that were made during that time frame that are being brought under the TCPA. Well, can a court enforce an unconstitutional statute? That's the question in CREASY. Unfortunately, believe it or not, you probably believe it, dozens and dozens of courts have found, sure, we can still enforce the statute, and that's just what they're doing. But there are two big appellate court decisions, one in the 6th Circuit and one in the 9th Circuit. They're going to answer this question, so stay tuned. We've got about 2 minutes left, so let's move to the next slide. TCPA 2.0, of course, this last thing I want to chat with you about. Everybody is saying, well, isn't Congress going to do something now that Facebook has really narrowed the reach of the TCPA's ATDS definition? And the short answer is probably not, at least not immediately. I'm working with others. I know CMBA may also be working. I know the MBA, ABA, other organizations are all kind of lobbying with Congress right now, trying to convince Congress that if you are going to do anything with respect to the TCPA, You need to abandon your faulty reliance upon regulating technology, that doesn't make sense, and regulate the actual content of the calls that you don't like. If you want to prevent scam robocalls from hitting Americans' phones, then why not make it illegal to, scam robocall people, as opposed to just using technology that bad guys also use when you're a good guy just trying to reach out to your own customer with a legitimate message. So trying to convince Congress that the new TCPA should be focused on content and not on technology is kind of the focus of some, at least, industry lobbying efforts. Additionally, you should be aware that there's a new act that the Senate is considering right now. It's called the Deter Obnoxious, Nefarious, and Outrageous Telephone Call Act. It's a terrible name, just a terrible name. And it adds criminal penalties to the existing TCPA. That's all it does, is it takes the existing TCPA and it says, if you violate it, you go to jail. I mean, it's black and white. I mean, that is literally what it says. So you want to really pay close attention to that, because obviously adding criminal overlay to an already extremely punitive statute is scary, horrifying, violates the First Amendment, but most importantly, none of y'all want to go to jail. Okay, so pay very close attention to that. Last but not least, if you haven't heard, the Florida legislature has unanimously passed a new statute that contains a private right of action that is just like the TCPA, except it uses the word auto dialer without a definition, which means that Facebook is probably not going to provide the rule of decision. And we have a new TCPA with a new auto dialer statute sitting down there in Florida with a $500 per call private right of action. And we're going to start all over again with all the battles over ATDS, only this time in Florida state court. Have fun, everybody. Hope you enjoyed the update. We'll chat soon. Bye-bye. Oh, skip this one. I'm all done.
All right, thanks a lot, Eric. That was awesome. I love the energy. All right, so I'm going to talk about a few issues relating to employment law, and I know that the intended focus was supposed to be on issues with remote work, which I will touch on, but I think I would be remiss if we weren't talking also about what's going on with workplaces in Cal OSHA. As you all know, or should know by now, the state is about to open back up on June 15th, which is just next week. Except we have this misalignment between the state rules and what's going on with Cal OSHA for workplaces. So generally speaking, folks are not going to have to wear masks anymore on June 15th. But Cal OSHA instituted its own emergency temporary standards back in December. And obviously they were due for an update. And so there were proposed revisions that were published a couple weeks ago towards the end of May, and they were voted on June 3rd. For those of you who are keeping track, it almost failed. They voted on it twice. First, they voted to shut down or to reject the revised rules. And then the Cal OSHA Standards Board realized, if we don't pass this, we're stuck with what we already have. So this is at least better than what we currently have, and we can work to improve it. But what we're left with is slight improvement, but there's still going to be some misalignment. And specifically what that means is, if the revised revisions of the regulations, they pass the Office of Administrative Law, they have 10 days to review it. But if it passes, it's going to go into effect on June 15th. And as of June 15th, we're basically going to have two different standards: one for everyday people, individuals, and those for when you've got your employment hat on. And when you're serving your capacity as an employee in any workplace, whether that's one designated by your company or one that you're assigned to, if you're fully vaccinated and you're in a room with only other fully vaccinated people, you don't need to wear a mask. You don't need to socially distance. But if there's anybody in that room who is not vaccinated, well, then everybody needs to wear a mask. Don't get me started on how we're going to execute on this and how we even know these things. I mean, certain counties like Santa Clara County, where I sit, the counties actually require that every employer determine whether their employees are vaccinated or not. But there are several options that employees have, and one of them is that they decline to state. One of them is they haven't been vaccinated yet. One's just simply, I haven't been vaccinated. If an employee doesn't respond or declines to state, all those people need to be treated as unvaccinated. And what that means is that in that particular workplace, everybody needs to wear a mask. But that's Santa Clara County, right? Not every county is doing the same thing. And so this is going to create quite a hurdle for employers. Frankly, even if you do know who's vaccinated and who isn't, are you going to be going from room to room in your office space, if you've got folks returning to the office, that is. So I think this may be one of the reasons that people are gonna hold off. You know, the flip necessarily would have created other issues that we don't need to deal with for the time being. But if the rule was instead, if you're unvaccinated, you got to wear a mask. If you're vaccinated, you don't have to. Now we got two classes of people within the same workplace. That's no fun either, right? I mean, it's like wearing a scarlet letter. It's a badge, and people are going to be judgmental about that sort of issue. So there's no great answers to these issues, but that's currently what we're going to be left with. Is if you're in a retail environment, when folks actually come into your storefront, they don't have to wear masks, but you as an employee will need to if all the employees in that workplace are not vaccinated. So I'll just sort of leave that at that for right now, and you know that we will be getting more guidance on that shortly. I do expect that it's going to pass the Office of Administrative Law and will go into effect next week. Second issue is COBRA premiums. I think this has sort of escaped a lot of employers. Under the American Rescue Plan Act, which was signed by our president on March 11th, as of April 1st, from the period of April 1st, 2021 to September 30th, 2021, if the company lets anybody go, it doesn't have to be COVID related. If they let anybody go, and it was other than for gross misconduct, the company needs to pay for those employees COBRA premiums. So if the employee enrolls in COBRA, that's their hurdle, then the company needs to pay for those premiums through September. Well, for 6 months up through September, right? So because it started on April 1st, it actually goes back to people that were let go as far back as November 2020. 2020. So what you would need to do at that point, and the deadline's already passed, so if you haven't already done this, please be aware that you need to identify everybody that you've let go since November 2020 and give them all notices of their right to enroll in COBRA and have it paid for by the company for at least the period from April 1st through September 30th, or whenever their COBRA period would run out. But September 30th is the last date for that. So that's something for all employers to consider, because obviously there's been economic impact as a result of the pandemic, and as a result, people have had to let people go. There may be certain divisions of your companies that needed to be let go because they slowed down. Well, there was an uptick in others. With all those folks, unless they resigned or they were fired for gross misconduct, they're eligible to have their premiums paid for. Now, the good news, and I should not forget to mention this, is that this is all reimbursable to the company. So we have to pay for it out of pocket, but then we can seek dollar for dollar reimbursement through tax credits. So in your quarterly state tax returns, you should be able to recoup that expense. That could create hardship, though, obviously, for certain companies who have cash flow issues, that we've got to pay it now and then seek reimbursement. But important for folks to know that that's what's going on, especially since, you know, even if you hadn't let people go before April 1st, there may be layoffs or terminations going forward. So this is in effect through September 30th. Now, the notice that goes out to employees is typically going to be provided by your benefits provider, but it's on you to make sure that your benefits provider is providing that new notice to let employees know that you can enroll for COBRA and we'll pay for it through September 30th. Okay, so moving on, to me, for folks who have been working remote and for those who will continue to work remote, the biggest issue of concern to me as an employment attorney, as a defense employment attorney, is expense reimbursements. I think this has been shoved under the rug by a lot of employers. And for good reason, at least for a period of time, but I'm sitting here going, I'm just waiting for the lawsuits to start pouring in. Because when we were first put on lockdown and everybody was told you need to work from home, we need to maximize telework, companies didn't really have much time to plan for all this. I've been advising clients for years that if you've got folks working from home, provide them with an office and a box, give them all the tools they need so they can work from home. Because otherwise you got to pay for their personal equipment, and you also don't have any control over that equipment, which is a bad thing. So this is not a new rule necessarily, and it all is primarily based on the Caren case, Caren versus Schwann's Home Service. It's a 2014 case where essentially an employee said, I'm using my personal cell phone for business purposes, so I should be reimbursed for that. And the company said, it doesn't cost you a single penny more to use your personal phone for business purposes than using it for personal purposes, because Based on your plan, you're not paying for minutes and data and all that. And the court said, that doesn't matter. That's not the way we look at it. Companies need to pay for their own operating expenses. And so if it's reasonably necessary for an employee to use a personal phone for business purposes, you have to pay at least a reasonable percentage of that cell phone. Now, the alternative is always the company can provide the equipment. If the company is providing adequate equipment and providing a cell phone, for instance, as in that case, well, then the employee doesn't have a good explanation for why it's reasonably necessary to use their own. So I always tell employers, provide your employees with what they need in order to carry out their duties from home. But that's, you can do so much, but then there are things like internet. Company can't provide an employee with internet. The employee is going to have to provide that for themselves in their home. It's because it's got to be attached to their name with their address. And chances are they've already got internet at home. Right, so that's the biggest one I would say. They've got internet at home, they're already paying for it, and now they're using it for business purposes, probably to a pretty large extent if they're working 100% remote. So under the Cochrane case, employers are obligated to pay for that internet, not necessarily for the entire thing, but just like with a cell phone, for a reasonable percentage. So of course, then there's the question: what's a reasonable percentage? Undecided. I think there's good rules of thumb. You can go with a percentage, or you can just go with a flat dollar amount. A lot of companies go with a flat dollar amount. They'll pay somewhere between $30, $40 per month. I think it's always good to sort of gauge what's the going rate for home internet, sufficient home internet, right? You're not going with that base package that's going to have your internet going unstable and causing Zoom to crash on you and whatnot. You got to provide adequate bandwidth and whatnot. So figure out what's that cost and pay for a portion of that. I have not seen a bunch of those claims yet, but I am seeing them. I'm seeing them in different contexts. I'm seeing them on site, and I think it's just a matter of time before I start seeing them off site, again, because it's been going on for the past 15, 16 months. But it's not just internet. I think, companies should be thinking about all types of equipment, the chair that the employee is using, the desk that they're using. You might have ergonomics issues that come up, and if you're going to have employees working remotely, those are important factors. Very important caveat, though. These all come into play when the person is working from home, because the company doesn't have an office to offer them. There's nowhere for them to go. They don't have a seat to sit in, and so this is really for the benefit of the employer. There are lots of folks, based on fear and otherwise, who are going to want to continue to work remotely. And maybe for childcare needs, whatever the issue may be. If a company voluntarily chooses to allow an employee to work from home, I would put lots of conditions on that. I think it's absolutely important to have a work from home agreement, but that is for the employee's benefit, not for the company's. And in the same way that if a company provides an employee with a cell phone, well, the employee is not reasonable in using their own. If the employer provides the employee with an office and says, here's where you can work, and this is the office to which you're assigned. If they choose to work from home instead, we don't have to pay for their expenses beyond those that obviously, they're gonna need in order to carry out their duties, like that aren't being provided, like maybe the ink for their home printer. But even then, the company can provide all of that. The company can provide staplers and all of that, the typical office equipment. So in that scenario, anything that's unique to working from home, I shouldn't say unique, the things that they need at home, but they have available to them if they go to the office, they don't need to be reimbursed for that. So I'll just draw that important distinction. But I think it's also super important to make sure you've identified which folks are working remotely for their benefit versus for our benefit, and what are we doing to provide for these expenses. And you can easily say, well, the employee didn't ask to be reimbursed, so I don't have to worry about this. That's an argument. It's not the one I would want to go into court with. Not that you're going to lose, but it's going to be very expensive and time consuming, and you may still lose, right? So that's not the best way to approach this, is just sort of turning a blind eye. And my concern is, because I've seen it myself with many employers over the last year, is that folks are just ignoring this issue and hoping that someone else no one will bring it up, or we'll deal with it in a few years, right? And then at that point, it won't matter for us. I don't think it's going to work out that way. All right, last thing I'm going to touch on is that I'm still experiencing quite a bit in my practice, class action and PAGA action cases. So this is litigation, and I think it primarily deals with meal and rest breaks. I mean, you can get class actions, or just let me step back. PAGA stands for the Private Attorneys General Act. It's different from a class action because you don't need to certify a class. It's basically you're bringing a lawsuit on behalf of the state of California. So you're a private attorney general. You're working on behalf of the state. The state doesn't have the resources, so they deputize individuals to bring these claims. And we're seeing a lot of these, and there's a lot of leverage that can be created by filing a lawsuit like this. One particular employee, they may only have a claim for a few $1,000s, but if they file as a class action or a PAGA action, all of a sudden we're talking about a few $100,000 because it's on behalf of a larger group and it's a representative action, and we're suing for penalties per employee per pay period. So these things can really mount. And meal and rest breaks still continues to be sort of the weak link for a lot of employers in their daily practices. And it's one more thing to worry about when you've got folks working remotely. Typically, traditionally, companies don't allow employees to work from home who are non-exempt, who are hourly employees. Exempt employees won't have to worry about tracking their time at all. We've all sort of, I shouldn't say all, but many of us have grown accustomed over the last year to saying, okay, we get it. We understand how hourly employees can work from home, and we can do so productively and effectively. But there's still this concern, and I'm sure you've seen it, hopefully, because if you're looking at timesheets, folks aren't working a 9 to 5 anymore. They're working all over the map because they're at home and they have that kind of flexibility. Unless you tell them you need to be available from this hour to this hour because those are office hours, that's where your team's going to be available and all that. And all that's legitimate. It may be that many of you are allowing employees flexibility and saying, yeah, I get it. You have family responsibilities, you have personal things to do. We've now blended the work and home environment. So we're fine with that as long as you're available during reasonable hours, and feel free to flex. You can work as late as you want, as early as you want, as long as you don't work more than 8 hours in a day. We still don't want you working overtime without authorization. Well, in that situation, what do the time records look like? My guess, based on what I've seen with most clients, is that the time records are still going to say 8 a.m. to 5 p.m., which isn't accurate. And as a result of that, you've got employees coming back saying, look, that's not accurate. Now I want to file claims because I didn't get my meal breaks. I didn't get my rest breaks. Rest breaks are really a far-fetched argument for someone who's working remotely, unless someone's really looking over their shoulder the entire time. But there's claims for meal breaks. We see claims for off-the-clock work. And, you know, the argument the employee makes is that despite what I submitted on my timesheet, you, my supervisor, you knew I was working because you were texting me, you were emailing me, you called me. So those sorts of things can really get companies into trouble. So it's important that we maintain a tight ship on our timekeeping practices generally, not just for meal and rest breaks, but for purposes of overtime, for purposes of avoiding off-the-clock work type claims. It's super important because unfortunately, I am seeing a pretty big wave of class action and PAGA action work that's coming our way. So it's not necessarily what I would be expecting. I'm expecting them for expense reimbursements. I think that'll come in the next wave. That's all for me. Thanks, guys.
Okay, last but not least, and boy, did I learn a few things, and it always scares the heck out of me when I start hearing about employment issues. But I want to talk to you all today about the current status of the eviction moratoria that exist across the country. So we're going to start with sort of just a brief history of how we got here, and then we're going to spend some time talking about the Alabama Association of Realtors case that came down, and then finally where we are in terms of the status of the moratoria. Although I guess the good news is now that we are actually in June, it is set to expire the end of this month on June 30th. I was recently somewhere where someone kept talking about June 31st, and I'm like, the last time I remember, there's still no leap year for June. But nonetheless, let's start with just sort of a brief history. So going back, which in some respects seems like eons and eons ago, but really not that long ago, on March 13th of 2020, there was the presidential state of emergency declaration as a result of COVID-19. And then on the 27th, the CARES Act was signed into law, which did include the 120-day moratorium against eviction on rental properties that had received federal assistance. So those loans that rental properties where the mortgage might have been a Fannie or Freddie type of mortgage. And who'd have thunk, here we are in June 2021 that we're still talking eviction moratorium. So then in August of 2020, President Trump issued an executive order which directed the Secretary of Health and Human Services and the director of the CDC to consider whether or not that temporary halt needed to be longer and whether or not, there was reason to impose an eviction moratorium on rental properties to help prevent the spread of COVID-19. And of course, as we all remember, we were all, and in many respects, continue to be in full lockdown quarantine. Then on September 4th, the CDC issued what really was the subject of the Alabama case, the temporary halt in eviction, residential evictions to prevent the further spread of COVID-19. And they found that it was a reasonably necessary measure to prevent the spread, noting that, again, as we were all in quarantine, if we were then evicting folks, they would be out on the street or likely to move in with other people or what have you, which could potentially cause a greater spread of COVID-19. Next slide. So what did they do? They basically prohibited a person from the ability to evict a tenant from any quote unquote covered person. The covered person, again, was a tenant who had to submit a declaration in order to proceed to receive those protections. And again, as we all have noted, a much broader moratoria because it was national and it wasn't just as to federally backed properties, what have you. This was a pretty extensive, remains an extensive moratoria on rental property evictions nationwide. It was originally set to expire December 31, 2020, and oh, if we had only been through this insanity by then. That order was extended by Congress through January 31, 2021, and then the CDC extended it through March 31 and ultimately extended it again through June 30th, where we sit today. And as of the 8th of June, I have not seen anything that indicates that there is an intent to extend it beyond that June 30th date. But again, it tends to happen later rather than earlier in the process. So I guess more to come. So as a result of the national eviction moratorium, next slide, or you're on the slide, Alabama Association of Realtors then filed a lawsuit in the United States District Court for the District of Columbia back in November of 2020, challenging whether or not the CDC had the authority, both on constitutional and statutory grounds, to issue such a moratorium, and said that their main argument was that they had exceeded its statutory authority. The plaintiff filed a motion for summary judgment on this, and defendants on the Department of Health and Human Services filed a motion to dismiss. In the Alabama case, the court held that in fact the CDC did exceed its authority, granted the motion for summary judgment, and denied the motion to dismiss. What we know is that there have been no less than 6 cases decided on this issue, and the cases have a split of authority. Some saying yes, the CDC has exceeded its authority, others saying it has not. Next slide. So the court went through a very extensive statutory construction analysis, which you can read in the case. It did note that, yes, Congress has granted broad authority to the CDC to prevent infectious disease, what have you, but unlike what the CDC was arguing in this case, one, it's not limitless, and there are some pretty succinct and distinct limitations. And that after going through the statutory construction, it basically said that, yet, although you have a broad authority, you do not, that this is beyond the authority that you were granted, that this was not necessary to combat the spread of disease, as was argued in the case, and that just saying that or arguing that anything that you want to do in order to limit the spread of disease is not constitutionally allowed, and that we are placing limits on your ability to act. Next slide. I've provided you with a quote in terms of what the court specifically said, but basically, as I said, they felt that it went beyond the enumerated abilities of the CDC and was beyond the statutory as well as constitutional authority of the CDC. There was an argument made that when Congress extended the moratorium for that 1 month, that somehow they ratified the CDC's actions and the moratorium. And again, the court rejected that particular argument, and again found that the national moratorium just was beyond the scope. So where are we now? Everyone was, when the decision came down, it was like, oh my gosh, there's, evictions are going to start moving immediately, and the world as landlords know it, we're going to become, quote unquote, more normalized. Well, that did not happen. And in fact, the court basically said, I'm going to leave the moratorium, if you will, in place to allow an appellate court to look at the decision here. So basically, albeit that the court found the CDC order to be unconstitutional because of the concerns that were expressed that as many as 400,000 cases are on hold, if you will, or have not been filed, and the potential spread of the disease, that this court was not going to immediately terminate the moratoria, but in fact allow the appeals process to begin and to have an appellate court or courts determine whether or not the CDC had in fact exceeded its authority. Yesterday, interestingly enough, the DC Court of Appeals did deny a request of a group of landlords to resume the evictions, again, leaving that national moratorium in place. So there had been an appeal specifically to determine that issue on whether or not the evictions could proceed. And this court said, no, we're leaving the moratorium in place. And again, most interestingly, indicated that they felt, at least this particular panel, that the Department of Health and Services had a strong likelihood of success on appeal. Now, and recall that I started by saying this all expires on June 30th. So it's very likely, if it is not extended, again, that the appellate process will not have run its course prior to the expiration of the moratorium on its own terms. last slide. So it is also, albeit we have this national moratorium based on the CDC order, it's also very important to recall that we have additional moratoria that are in place regardless of the CDC order. FHA has extended its ban on evictions on properties that are secured by FHA insurance on single-family mortgages, again, through the end of June 2021. Fannie and Freddie have similarly the same type of moratorium and are prohibiting the eviction of tenants through June 30th. Theirs on single-family properties, but they also have certain moratoria that affect multifamily properties. It's important to know that many states also have eviction protections as well. California does have an eviction ban against tenants with very specific requirements and declarations, etc., that have to be filed, all again through June 30th, 2021. So in sum, I would say that we have 22 days left of the all of these moratoria. I don't, as I said earlier, don't have any indication that of what the CDC is likely to do. We certainly have rules affecting foreclosure that CFPB has presented that are not finalized yet. But as of right now, it is entirely, if we assume these will expire on June 30th, we may very well start to see evictions on rental properties starting to proceed within the normal course, subject to, of course, judges who are as people too, what may happen with the actual eviction process. But we anticipate the world opening up as far as evictions on July 1st.
Great. Thank you, Caren. And if you have any questions, please submit them through the question dialog box. And Dustin, can you tell if we have any yet?
Nothing yet, but yet, as Rich just said, yeah, there's a questions option there in the GoToWebinar module there. So go ahead and enter your questions in now, and we've got just a couple minutes left. I will note, as Rich noted as well at the beginning, that the webinar here is being recorded and will be available on either the legal issues page on the California MBA website or on our YouTube channel, and that'll be up probably tomorrow afternoon or so. And Rich, I see no questions at the moment, so I think that we can probably skip to our last slide here, and if anyone has any follow-up, they can certainly reach out to our speakers directly.
Very good. And thank you for attending. Also, if you have any issues of particular interest that you would like addressed at a future Legal Issues Committee webinar, please contact Dustin with your suggestions, and we'd be happy to consider them for future topics. Thank you for attending, and I hope everyone has a pleasant remainder of their day.
Bye-bye.
Thanks a lot, everyone.